Planning for the future isn't always easy, but it's one of the most important steps we can take to protect the people and assets we care about most. From wills and trusts to probate and estate planning, understanding the law can make all the difference. Professor Gail Richmond helps us to break down what you need to know. Welcome.
Thank you.
Such a pleasure to have you. And this topic is one that is just not going away. We know that.
Well, death does happen.
Right. So tell us about the law in Florida as it pertains to wills.
All right. The Florida Constitution says that everyone has the right to possess and protect, et cetera, their property. But once you're dead, it's probably not going with you. So how do you transmit your property from you, not you, of course, to those people or institutions such as charities that you want to benefit? And there are several ways you can do it, but one of the ways that everyone thinks about, I think, is a will. But you don't need to use a will for all of your property, and I suspect that many people who haven't even thought about estate planning or wills already have done some alternative planning. For example, they might have a joint bank account, and when they die, it simply goes to the other person. Or they might have life insurance, and that goes to somebody else, and you don't need a will for any of those things. But then there are a lot of things for which you might want to have a will. So your car, your home, although there are limits there, your furniture, all of your mementos, things that you don't tend to own in a survivorship or beneficiary form. And of course, you have two choices. You can have a will, or you can die without a will and be intestate. And what you give up when you are intestate are several things. Number one, you give up the right to determine who is going to manage getting your property from you, the decedent, to your creditors, because they come ahead generally of your beneficiaries, and then to your beneficiaries. You give up the right to determine who your beneficiaries are. If you have a relative who is a potential intestate heir and you and he or she don't speak anymore, if you're intestate, you're out of luck.
Yeah.
But if you have a will, you can just ignore them. So wills give you a lot more power, and so I think everyone should have one. Although, of course, not everyone is eligible to have one, and that's
Tell
a
us about
starting
that.
point. In Florida, to have a will, you have to be at least 18 or an emancipated minor. And to be emancipated in Florida generally requires either that you get married or that you are age 16 and your parents go with you before a judge and get an emancipation order. So some of these prodigies who are 14 and 15 years old and they get court orders allowing them to earn money, they still can't write wills because they're not old enough to be emancipated. But assuming everyone is of age, you then have to be of sound mind. And the older you get, the more risky it is that some disappointed relative will claim, oh, grandma wrote that will, but she didn't really mean that. She didn't know what she was doing, and then the whole will is invalid. So having a relationship with doctors and so on who can attest that you were
Of sound
mind is a good thing. So once we've passed those two hurdles, and of course you can write in your will, I of sound mind. That's just self-serving. It doesn't do you any good. Then we have the procedural requirement, and this is an absolute rule. You, the testator, must sign the will, or have someone else sign it in your presence and at your direction. Maybe your hands are in casts or something and you can't sign. But the norm is you will sign your will.
And with how many witnesses?
Ideally, you will sign with no fewer, you have to have at least 2 witnesses in Florida. You might want to have more. They have to watch you sign or hear you say that you signed before and acknowledge that what's in front of them is your signature. Then they each have to sign in front of you and in front of each other. That can't be waived. That's an absolute rule in Florida. So if, for example, someone moved here from Michigan, where you can have a holographic will that's valid, it's completely in your own handwriting, but no witness is required, that will is not valid in Florida. But you could validate it by signing it in front of two witnesses and having them sign it.
Very interesting.
So you don't necessarily need a whole new will each time something happens.
Talk about the limitations of a will.
The limitations of a will. Okay. Number one, this is a biggie. If you own a home outright, your own name, not jointly with your spouse or someone else, and you have a minor child, you cannot validly devise your home by will in Florida. Now, you can still put a devise of your home in the will in the hopes that you won't die until the minor reaches age 18, because we judge the validity of the devise at your death, whereas we judge the validity of the will when you execute it. So if you're not of sound mind when you execute it, it doesn't matter if the devises were valid, because the will isn't valid. But if you don't have a minor child, but you do have a spouse, in Florida, the only person to whom you can devise that home, assuming that he or she didn't waive it, is your spouse. But the payback for that, not being able to devise, is that MasterCard, Visa, your doctors, they cannot take your home. Only the mortgage company can take your home and your tax liens and so on. So you give up the right to devise to some extent, but you get protection from your creditors.
That's good.
And so that's a good thing.
That is.
You also can't disinherit your spouse in Florida. It doesn't matter whether you have a will or whether you're doing all of your planning through life insurance, et cetera. In Florida and in, I think, every state but Georgia, I think, we have an elective share. And every state is different, of course, but in Florida, the spouse is entitled to 30% of the value of your elective estate, which includes your probate estate and the cash surrender value of your life insurance and your part of jointly owned property and any revocable trusts you set up and your pension rights, if there were survivor benefits, all sorts of things, and gifts you made within 1 year of death, above the federal estate, the federal gift tax exemption. So
there's so much, so many things to know, which is all the more reason why people should not be doing this with downloadable forms. So we appreciate you sharing your expertise and putting it on the radar of the audience of some of the issues to be considered. And we appreciate having you on today.
Oh, my pleasure.
Thank you. The professor has helped us better understand the importance of wills and estate planning. These are conversations many families delay. Her guidance shows why planning ahead truly matters.